Hey everybody, great to see you tonight. I am I'm glad to be inside. Uh, I'll give folks a few minutes to get connected, to find the spot where this video is at, and to kind of make their way in. Uh, but I can say that it is definitely hot, and I think anywhere you're at in the state of Texas, you'd say the same thing. Thank God for air conditioning. Uh, Hey, I love being with everybody in Texas, and I've done some of these live events for people around the country. I was doing one in California, and then in Florida, and then in Georgia, and I always have to keep it general in those cases because I'm not licensed to practice there. So I am licensed to practice in Texas, and so I'll start the introduction that way. My name's Ron Baranski. I've been licensed to practice law in the state of Texas since 2003. I have focused in the last 10 years primarily on estate planning. And I would say roughly 95% of my practice is estate planning today. A little bit of contract review, but the rest is estate planning. That include wills, trust, and then the associated documents that go along with that. Um, so I'm going to start kind of how I have done in some other states, but I think it's so important. I think it's important to you to put two documents in your plan right now. They don't cost you much money. I mean, you can even if you'll DM me, I'll find these two documents for free that you can fill in and get completed and have set up. First one, you need a statutory durable power of attorney because with that document, a trusted family member or friend you name as your agent can step into your shoes and can address any kind of financial matter that you would normally handle. So let's say tomorrow uh, you have a car wreck. Those happen, but maybe this was a bad one. You're in the hospital 6 months, or you just laid up and really can't get out. You could sign a document, but they'd have to bring it to you. Either way, irrelevant. Your agent can go and sign on your behalf. They can handle financial affairs. They can deal with real estate. If you grant them that authority, they could deal with the IRS and signing that 1040 I love you USA IRS form that comes up every April that we so much love. Uh, they could deal with a post office, signing your name for a package, changing your address. There's lots of things that could happen. If you don't have that, what happens tomorrow? You're in an accident laid up. Let's say it goes a month or it goes 2 months. Who's going to take care of those things? What's going to happen there? And the only option your loved ones have is to simply go get a guardianship proceeding set up on your behalf. And so they go to the probate court and they have to make application to be your guardian, and they have to post a bond that would cover what's equal to your estate. Sign off on paying somebody to post bond for that amount. So that's a real important document. Statutory durable power of attorney. That covers kind of finances and property. The other one, similar in vein, a medical power of attorney. Uh, Only key difference there is the medical power of attorney doesn't take effect until you can no longer communicate your wishes or desires. And so your medical power of attorney, you name an agent like you did before. It doesn't have to be the same person. In fact, in my family, uh, I was named as my parents' agent on the financial side, but one of my sisters was named their agent on the medical side. They live in Oklahoma, so it just made sense. And she lived right near them, and so that made sense. There's a third document that kind of lays behind that, and that's called a healthcare directive. I call it the pull the plug document, but jokingly, that's the document where you indicate that if providing all means possible, even with that, you're still expected to die within 6 months. You can check a box and say, I don't want it. Same if you're in a irreversible condition, more of in a coma that requires artificial means to keep you alive, but there is no likelihood that you'll ever progress out of that state. Doctors aren't God, so they don't know everything, but I generally would like to make that call myself to some degree, and I think you probably would too. And so your healthcare directive is a document you indicate either I don't want any of that stuff, or I want everything modern medicine can do to keep me alive. Why I bring that up is because your agent that's named in your medical power of attorney is required to follow that. But I want to add something here and say that not only having that in writing is important, just as important is both telling that agent, along with all your close family members, what your desires are. I say that so that you don't have an event come up where you get to the hospital and somebody says, well, what would Dad want? They're saying they got hook all these machines up to him, and then maybe there's a conflict. And I tell you now, if you got 4 or 5 kids and one of them starts screaming the loudest, the hospital's going to hook you up to everything they got. That's why I say communicate to all your close family members, because then they can say, Dad told us what he wanted. He didn't want any of those machines, and he put it in writing to back it up, and he gave a copy of that to me and the hospital. So they don't have any guilt in moving forward in that direction or in the other direction. Like I said, if you want everything, that's your legal right, and that's what that document's provided for, is so that you can have them hook you up to all they've got and keep you alive. And at that same time, if a child is talking about, well, that's a waste of our inheritance or whatever, the rest of them can say, Mom told us that she wanted all this stuff and she wrote it down. So those, a medical power of attorney and a statutory durable power of attorney are the 2 documents. And they're so important. If you will DM me today, I will find you a link to where you can get them for free. They may be something that you fill in, a PDF form where you fill it in yourself, but I'll find them for you. You send me a DM, reach out to me in some way, and I'll get you a link to those. Now I wanted to move on and just talk about kind of what are the differences with a will, without a will, how does that work? I do want to deal with one misconception, and it's been around for a long time. And, we know what the last will and testament is, or the will. We've seen the Perry Mason shows or whatever it may be where, the dad goes down to the attorney's office and signs the will in front of 2 witnesses and a notary, and then he brings it home, puts it up, and, maybe he tells you, it says, I took care of my affairs. I went down to the attorney and took care of them. So if something happens to me or Mom or both of us, you know where to find that document over in that box. You go get it out, and it'll tell you how things should be split up, and you just split them up and go on your merry way. It doesn't work that way. It never has. I probably had that misconception way before law school as well. But a will has no legal effect until a probate judge has deemed that it meets the statutory requirements for the state of Texas. So you have to have two witnesses. All attorneys nowadays go further, and we add a one-page document where the two witnesses sign, and the testator, the person that signed the will, and the notary notarizes it. And that's a document where all of those people swear under oath that the testator told them, this is my last will and testament, and I am asking each of you to witness me signing it. And we were all in the presence of each other when he signed it. All that means really is it's called a self-proved will. That means when you go to probate, you don't have to go try and find one of those two witnesses. So that's something that is rarely missed, but sometimes people may do it online, something like that, may miss that. So the key difference then is if you write the will, then you decide where your property goes. And if you've only been married once and the children you have are of the single marriage, then things are probably going to happen like you'd expect. You're just going to spend more money in probate. Because if you don't have a will, the probate judge is going to appoint an attorney to review the application somebody made on your behalf to probate your estate and to verify the errors and to call and to investigate and to see if maybe somebody was left off this list that needs to be named. And so that in itself is going to probably cost you $750 to $1,250 in that range. That's an adder you get when you don't have a self-proved will to go into probate with. I may have said it, but the will is there to let you give property to whoever you want. Even if you have children, you could give it to anyone you want. It doesn't matter. That's how it's set up, and that's what I tell people. Occasionally, people go into stories about how that their 60-year-old daughter, after they wrote multi letters and sent cards, when they called them finally, they said, "I do not ever want to hear from you again. Count me as dead to you." And I really feel like they have a need to explain to me why they would disinherit that child. But they don't. I'm not concerned. All I really need to know is the name, and then I can take care of writing a will that addresses that. And so we never really expect these things, but they happen. To good families, bad families, things happen. I would say that the other choice you've got in a will that you wouldn't have going into probate without a will is to set up a trust that only comes alive inside your will. So if you and your wife perhaps die, then this will, we call it a testamentary trust because it comes about during probate. But this trust is drafted at that time by an attorney, and that would be paid for out of your estate. And it might, if you have minor children, then you would name a trustee that would take care of them financially. It might be the same person you name as their guardian, or it could be somebody else that's just good with money. But you have that ability within a will. And the same thing there is if you have adult children that, sadly, I'll bring this up, but if they are addicted to illegal substances, have some addiction issue, then a trustee can hold off on distributing any funds to them. Typically for 12, they can pay for rehab on their behalf, and they can ask for a drug test once a month for the next 12 months when they get out. Then they go back to payment as usual. Or if you had a child that we call a spendthrift provision, but it's some wording that provides that they only get an allowance, basically. They don't manage money well, and you know that. So to drop $100,000 in their hand, you know that'd probably disappear quickly. A benefit to that is that it also prevents a creditor from suing and being able to reach the money. Or if they go into bankruptcy, they can't reach that money. So those are things to consider. Most of all, I would say that the time you spend with your attorney in estate planning is not so much about how to write a document or the kind of paper you get. It's his expertise or her expertise in guiding you to achieve your goals, your objectives, and to make you aware of the potential pitfalls that could happen if we go that route. Or if we go that route, here's the way I'm going to write it to address that, because we have experience in dealing with that happening. And we also talk to a lot of other attorneys in our practice area, and they tell us the stories. And those are usually the sad ones. I had a judge tell me this once, that the worst time you meet people is in family law, which is divorce court, and probate. The best time you meet people is criminal court. The criminal guys always want to look good and act good. Said the other two, they act crazy. So I'll leave you with that, and I'll say just reach out to me if I can help you. I hope this was educational to you. If you could do me the favor of putting in a hashtag value, if you got value from this. Also put in a hashtag live if you're watching this live. And lastly, put in a hashtag replay if you're watching it on a replay. That just kind of gives me an idea of when people watch things, because maybe I could move times around. You could even put that in the comments that it'd work better for me if it wasn't Thursday at 6 p.m., but it was Monday. Or just put a comment in or send me a DM, and I can move things around and make that work. And again, I hope you found this valuable, informative, and reach out to me if I can help you. Thanks so much.